Hey y'all, this is David with I'm So Offended. Um, gonna do part two of the family law custody of responding to a Rule 83 and Rule 84. So we're just gonna continue on, but as always, um, I'm not an attorney. I don't practice law, and this is not legal advice. Any information here is for entertainment and informational purposes only. I'm not liable for what it is you do and your outcome. Each place and state is different, so let's get into it. So we left off with they filed a Rule 83 motion and a Rule 84 motion against me, right? And we read what it was and the whole bunch of nonsense, and we had to take a step back in order to see what is it that they want and what are they using to get what they want and what are they requesting. Okay, so I don't if it I mean I'm sure a lot of you are busy and you don't want to just sit there and dissect my cases and figure out what I'm doing with my thing. And so whether or not you comment as far as what it is that you would do and you were to look it up if it was your thing or not, I'm still going to post like what's going on with me because again, it might help somebody, who's going through this. So, and also it might teach them to how to figure out responding to motions and and these rules and what to look up. All right. So, they invoked a Rule 83 motion to alter or amend a judgment, and they invoked a Rule 84 motion for clarification. So they filed those motions, and instead of getting frustrated with all of the lies, I looked up the rules to see what it was they were doing. So here we go. The Rule 83 that they wrote, they were seeking grounds to alter or amend a judgment, and they even quoted it. The court may, or on its own, or on motion, alter or amend all or some of its rulings on the following grounds, materially affecting a party's rights. And if you can see that the attorney used part of the rule to make their argument. So he used quotes from this rule in order to make the argument. So that's all law is. There's rules, you make your argument, and you reference the rule. Okay? So, the court did not properly consider or weigh all admitted evidence, any irregularity in the proceeding or abuse of discretion depriving the party of a fair trial, misconduct of the other party, accident or surprise that could not reasonably have been prevented. You can read through all of this, right? So how am I going to respond to their Rule 83 motion, right? Okay, so I was reading through it. Okay, they're using the first part. They're using A1. They're using newly discovered material evidence that could not have been discovered and produced at the trial with reasonable diligence. And they're using G, mistakenly overlooked or misapplied uncontested facts, including mathematical errors which are necessary for the ruling. Okay. And then it said, the court may vacate the judgment if one has been entered, take additional testimony, amend findings of fact, conclusion of law, or make new ones, and direct the entry of a new judgment. The relief, if granted, must be limited to the question or questions found to be in error, if separable. All right. So I was looking at this. I was like, what do I do? What do I do? Okay, I see this. This is how they're using the rule. Okay. And then I came to this because every single rule, when someone files a motion against you, they all have rules how it's supposed to be presented, what it is they can use from that same rule to respond to it, and then how to basically the rules regarding that rule as far as when they're allowed to file it. So then I come down to this part. Time to file a motion, scope, response, and reply. Motion. A motion under this rule must be filed not later than 25 days after the entry of judgment under Rule 78B or C. This deadline may not extend by stipulation or court order except as allowed by Rule 4B2. Now, this might be nonsense, right? Like, how do we know this shit? Like, what the fuck is this saying? All right. So we break it down. Motion under this rule must be filed not later than 25 days after the entry of judgment under Rule 78B or C. Okay. Do we have a judgment under Rule 78B or C? And then that's when I looked at the modification for the parenting plan and the trial that we went through, and the final statement that was written there by the judge is that this is final orders under under Rule 78B. That's what it said on the modification. So I'm like, okay, so that means this applies. See, you got to go down the rabbit hole. If it tells you this can't be used unless it's this rule, or if not, then it could be that rule, then go to those rules. Look up what they say. Turns out we had a judgment under Rule 78B. That judgment was entered October 24th, 2022. The motion that they filed was January 17th. Was it later than 25 days? Yes, it was. It's over. It sounds very, very simple. Very simple. But sometimes it is that way. This is what these attorneys do. All they want to do is take advantage of you because you don't know the law. So they will file their motions regardless if it's timely, if it's proper, if it follows the rules, if it meets the requirements. They don't care. They are only hoping that you don't know it, that you don't catch it. But all of these things, they purposely do it to take advantage. Now think of how disgusting these people are, that they knew. He knew. They knew that it was untimely. It is time barred. But they filed it anyway. But here's the real kicker. The judge could have dismissed it on its own. The judge could have just said their motion is untimely and could have denied it on her own. But they allow the fraud. They allow the attorneys to do this. These judges don't care. They don't care. They allow people's rights to get violated right in front of them. And his untimely motion, filed several months after judgment under Rule 78, was heard. She allowed a hearing to happen. These people don't care. And that's just the Rule 83. They filed a Rule 84 motion for clarification. Now, I went to the rule because they filed this separate motion. A party may file a motion that requests the court to clarify a ruling if the ruling is confusing or is susceptible to be more than one reasonable interpretation. A party may file a motion for clarification at any time, which is fine. This is different from the Rule 83. But the motion does not extend the time for filing a notice of appeal. And then it says procedure, unless the court orders otherwise, a party may not file a response to a motion for clarification, and the court may summarily deny the motion. Basically, the court on its own can deny the motion. That's what it says. The court may summarily deny the motion. However, the court may not grant a motion for clarification without providing the non-moving party an opportunity to file a written response. So the judge could have denied it on her own, but she's not going to grant it unless the other party, the non-moving party, has an opportunity to file a response. Okay, so a party may not combine a motion filed under this rule with a motion under Rule 83. Oh, oh. So they filed a Rule 84, but they cannot combine it with a Rule 83. And they filed a Rule 83, but they filed them separately because they can't combine it. Why? Because he knows. They knew what they were doing, and they were just hoping that I wouldn't catch it. So on a motion for clarification, the court may not open the judgment or accept additional evidence as it can under Rule 83. May not accept additional evidence. So what did we have here? Their Rule 83 motion was filed time barred, past the 25 days. Their Rule 84 motion was filed with additional evidence. Yes, it be like that. It's simple, right? It was that simple. So, what did we do? Here's what we did. Here we go. Let's show these fuckers how we handled them. All right. Let me open this up just a little bit more. There we go. Petitioner's response to respondent's motion to alter or amend a judgment. Motion is time barred and not allowed to be heard under Rule 83. Let's get to it. I, sworn and deposed, penalty of perjury. Petitioner's response. Look how short this is. Look how short this is. A whole bunch of jargon wasn't needed. A whole bunch of law wasn't needed. What was it? Respondent and her attorney filed a motion to alter or amend a judgment that starts with, and I used their motion. Respondent Kimberly Hadley, by and through her an attorney, used Family Law Rule 83 and submits the motion to alter or amend a judgment. And there it is. According to Rule 83, in which respondent and attorney requested relief through, it is stated, Rule 83C, time to file a motion, scope, responses, and reply. 1. Motion. A motion under this rule must be filed not later than 25 days after the entry of a judgment under Rule 78B or C. The final order was entered on October 24, 2022, and respondent and her attorney, Richard Winry's motion to alter or amend a judgment was filed January 17, 2023. Therefore, respondent's motion to alter or amend a judgment is time barred and not allowed to be heard under Procedural Rule 83. Petitioner requests respondent's motion to alter or amend a judgment be dismissed. Yes, it be like that sometimes. That's it. Verification. Boom. Fuck off. And now we got our... Which one is this one? Oh, it's still showing the other one. Oh, I gotta remove it. There we go. So now we have this one. So what was their Rule 84 motion they filed? It had additional evidence. You saw it had attachments, attachment A, attachment B, attachment C. Well, here's my motion to strike additional evidence according to Rule 84 and objection to relief were requested. Okay. Respondent filed a motion for clarification on January 13, 2023, wherein the motion respondent attempted to add additional evidence. The motion starts out stating the following: respondent and her attorney, pursuant to Rules of Procedure Rule 84, therefore submits motion for clarification or ruling on supervised visitation and parenting time. According to Rule 84D, on a motion for clarification, the court may not open the judgment or accept additional evidence as it can under Rule 83. Therefore, the evidence and attachments from respondent's motion for clarification cannot be accepted. The motion is only for clarification purposes of final orders ruling already entered October 24, 2022, pursuant to Rule 78B. This includes any testimony by the agent, since it falls under evidence that may not be accepted under Rule 84. Because in the hearing, which I also have, and I'll eventually play for you, they had gotten the agent from the the therapeutic place that was going to testify to her report. And so then I'm objecting to their relief requested. Respondent's first point of relief requested was to clarify the current orders in this manner to reflect the recommendations, which Rule 84 states additional evidence may not be accepted. So I just went point by point. Remember when I told you, you just look at the first thing they asked as far as the rule they invoked, and then the last thing, the list of things that they are using and requesting. So I went one by one, notating the things that they were requesting. Okay. Respondent's second point of relief is to set a review hearing following the time set for supervised visitations to consider the therapist's evaluations as to whether the child both feels safe with the petitioner and in fact isn't safe with the petitioner, and whether to advance to unsupervised visits. This falls under same circumstances under Rule 84, in which additional evidence may not be accepted. Therefore, petitioner's motion to strike additional evidence according to Rule 84 except their I'm saying this falls into the same circumstance under Rule 84, in which it may not be accepted, which is the rule in which the respondent's relief is requested through. Respondent's third point of relief is to order this supervised visitation on Wednesday from 3:30 to 7:30 with the designated place to be chosen by respondent and supervisor for their convenience. The respondent has a full-time job and goes to school. Her schedule is not at all flexible. Petitioner claims to not work and has not commitments to limit his schedule. That's what they said. And I say petitioner objects, as there is a final order pursuant to Rule 87B entered on October. I made a mistake. That should have been 78, not 87. On October 4, 2022, which was the conclusion from a trial for modification of parenting time, in which both the respondent and attorney were present and gave testimony, which means respondent had the opportunity to be heard and make any requests and submissions regarding schooling, scheduling, parenting time, and locations, but they chose not to. The final order from October 24, 2022 does not say that location shall be chosen by respondent and supervisor only. Therefore, the petitioner has every right to be given the opportunity to be heard and give input as far as location. The final order ruling dated October 24, 2022 does say the petitioner and respondent can make agreements, and the petitioner offered the respondent the opportunity to discuss parenting time and other issues since the ruling. However, the respondent refused. Yeah. Always try to settle these matters. You know, they hate it when you contact them and say, hey, can we settle this? Can we settle this? You know why? Because that means you're trying to avoid conflict and you're trying to avoid litigation. Yeah. Do this every time. Every time an attorney is requesting fees from you, every time offer to settle. Every time. And then let the court know that you offered to settle. Every time. They hate it because that means that they are causing controversy. Respondent's fourth point of relief is to this is what they said, order that should the petitioner be late or miss a scheduled visitation, he does not get makeup time, his time is waived. And then I stated that point is an obvious and reasonable point in which petitioner does not object to entirely unless there is an emergency situation in which can be reasonably forgiven by either party as long as emergency situation is true and genuine. Additionally, the same shall be said for the respondent, that if she shows up late or misses a scheduled visit, then it is the petitioner that should be afforded the make-up time and or additional visit depending on what action transpired as far as either a late visit or scheduled time. Respondent's fifth point of relief, to order petitioner to pay all costs with associated with supervised visitations. The final order ruling dated October 24, 2022 states that petitioner for paying all fees associated with parenting time, and petitioner has been paying them by either petitioner's own money and the expedited fund approved by the court. However, supervised exchanges is not part of the parenting time. Petitioner objects to pay all costs associated with supervised visitations, as supervised exchanges shall be paid for by both parties equally, which is fair, equal, impartial, and unbiased ruling. And then respondent's sixth point of relief is to order the petitioner pay all attorney's fees and costs. Petitioner objects, since the petitioner did not hire Richard Wintory to be as an attorney. The petitioner has no contract with Richard, and that's her attorney's name and all. Respondent and her attorney's filings were filed by her attorney and respondent of their own free will, of which the petitioner did not force them to file nor give them consent to bother the petitioner. Therefore, the petitioner requests that this court strike respondent's additional evidence under Rule 84 and objects to respondent's relief requested, where petitioner clarified in his responses herein regarding location, time, scheduling, emergency situation, and supervised exchanges. Petitioner also requests that this court strike and warn the respondent and her attorney of the use of the word kidnapping regarding the petitioner, since Judge Sklar had already instructed respondent and attorney not to use the word kidnapping during trial. This court may review final order ruling dated October 24, 2022, and will find that Judge Sklar did not use the word kidnapping once. And that's it. Here's my verification. Simple. 1, 2, 3, 3.5 pages. That's what it did. And so we come to their response. So they did another response because they're the moving party, so they get to have another go at responding again. So they couldn't. All right, so let's just go through it. Give me a quick second. Hopefully I haven't lost you here, in getting into like specifics about all this, and if you're still here, it's because maybe it'll apply to you or has applied to you or for whatever reason. But this is just something that I went through. All right, so here we go. They filed a reply to petitioner's response to respondent's motion to alter amended judgment. So respondent, through her attorney, regarding Rule 83, submits this response. So he's saying that the judge issued an under advisement ruling on October 24 regarding the phases of petitioner's graduated parenting time plan, and reviewing the ruling, the respondent realized for the first time the petitioner's parenting time was expanded to 4 out. They're repeating the same thing. They're repeating what they didn't address is that I brought up that it was time barred. So I don't have to read through this whole thing, but if you remember from the other video, they're just repeating the same thing. The ruling order respondent to lose every weekend for her trips, and the opportunity, and they're saying again, prior to the ruling, the court made no inquiry of the respondent, nor was the respondent given the opportunity to provide input of the times for petitioner's parenting times. They went to trial. We went to trial, and they submitted no parenting plan. So that's an obvious, massive lie. So, and then 2, notwithstanding petitioner's response, the respondent directs the court to attention to the court may on its own alter or amend some of its rulings materially affecting a party's rights, which is not affected by the time limit. So here they addressed the fact that it was time barred, that the court may on its own alter or amend the judgment. So with emphasis of the rule stating materially affecting a party's rights, respondent and child like to visit family in Arizona. He was repeating the same thing. Child is a cousin. It's usually a 2-day trip, and they're going to take that weekend away. Like, they're robbing me of 6 days I don't get to see my daughter, and I only get to see her like an hour a week right now. Um, and they're being and they're accusing me and saying that I'm robbing them of time, right? Even though I barely get to see her, you know, it's such nonsense. So, um, and then 4, in following petitioner's acceptance of Rule 83 by his citations from the same, he's aware the response must address any issues raised in the motion unless limited by the court. The response must also address any issues that might arise if the motion is granted. The petitioner did not address an actual single issue stated in the respondent's motion to alter amended judgment. He appears to agree with the amendment of that decision. See how tricky they get, you know, where because like I didn't address any of the specifics. He's saying, well, so since he didn't address any of the specifics, he must agree with it. These people are cruel. They're evil. So wherefore the petitioner, they fucked up again. This guy's a fucking moron. Wherefore, it should say respondent request that this court grant the following relief: revise the petitioner's parenting time to be every other weekend instead of every week, enter an order for such other and further relief as to the court seems just and appropriate. So we read my motions, we read theirs, and then their reply, and we had a hearing. We had a hearing. And this is how it went. All right. Here we go. There's the entry. Respondent's motion for clarification. Both parties present. Exhibits. Therapeutic report. Photographs. These are things that are identified, right? Understand the difference. Something could be identified, but that doesn't mean it's admitted. Okay? Pay attention to things like that. All right? If they identify something, they identify it. But if it's not admitted, then it's not admitted. Court counsel and petitioner. So all of this stuff that they submitted, the reports, some agreements, some photographs, some policy, and then the court counsel and petitioner confer regarding the status of the case and the issue of parenting time. Counsel and petitioner argued to the court. Court finds that the relief that the respondent seeks through Rule 84 is not available to her. Therefore, it is ordered that the motion is denied without prejudice to filing a motion under Rule 85 to accomplish the same or similar relief. We'll get to that. It is ordered that the respondent's motion to alter or amend a judgment under Rule 83 is denied as untimely. The court does not have discretion under the rules to extend the deadline for a party to file a Rule 83 motion except for excusable neglect. There was no excusable neglect present in this case. The respondent is granted leave under Rule 85 to file a motion or alter or amend a judgment on the appropriate grounds. The petitioner is granted leave to file a Rule 85 motion for relief on the bond. It is ordered that the petitioner's motion to strike additional evidence under Rule 84 is granted without prejudice to the respondent submitting the same or similar in connection with Rule 85. David is sworn, testifies concerning recordings he made at the agency in anticipation of respondent filing a Rule 85 motion within the week. It is ordered setting an evidentiary hearing. Respondent's Rule 85 motion. There's the date. Ordered not, exhibits filed in court. There it is. Pow. That's it. Defeated. Both. Simple. But they fought. They fought and they said a whole bunch of nonsense in court. Just a whole bunch of lies, kept calling me a kidnapper, just a whole bunch of lies. Whole bunch of lies. But I focused on my position. I wrote everything down that I needed to say. I focused on my position. And for part 3, I will show you how the hearing went. Alright? Alright. Leave me comments, see what you think, see if any of you has gone through it or whatever. Alright?